The entire debate, presentation, all that, objections, walkouts, all that took place during the night. Nothing during the day.
मतलब ये इससे मुताल्लिक तो नहीं है अभी
जी सर, मैं सिर्फ इंस्ट्रक्टिव टेक्स्ट दे रहा हूँ।
देखिए ना, जो स्टेप जब आएगा 26 अमेंडमेंट का, उसके ऊपर फुल स्टैंड पे आपको सुनेंगे। अभी कॉन्स्टिट्यूशनल बेंच पे है, अगर आप इस पे करें तो
उसी पे करो, उसी पे करूँ।
हम इसको इस तरह
लेकिन ये तो एक बेसिक फैक्ट है।
हम इसको इस तरह, हम आपकी बात से इत्तेफाक करते हैं। नो डाउट दिस इज वेरी इंपॉर्टेंट केस। यहाँ से बाकी बातें आप जो मेन केस आएगी उसमें आप बताएं कि किस तरह हुआ, अच्छा हुआ, बुरा हुआ।
मैं उसमें नहीं जा रहा इस वक्त।
दिस इज वेरी इंपॉर्टेंट। अब आगे चलें।
इस वक्त जो बात मैं करूंगा ये फुल कोर्ट के कॉन्टेक्स्ट पे होगी, मेरिट्स पर नहीं मैंने जाऊंगी। सिर्फ एक फैक्ट बताना था। At that time, meaning thereby 20th or 21st, the total strength of the Supreme Court, this one court was 17, including the Chief Justice of Pakistan. On 20th, 21st of October, there were 17 judges of this Honorable Court, including the Chief Justice of Pakistan. But on the 25th of October, the Chief Justice at that time retired, and therefore the strength of the judges of the Supreme Court on after the 25th of October 2024 was 16 judges. So in this petition, we are seeking the hearing of these petitions by full court, which means the full court in existence at the time of the passing of 26th Amendment, which means, may I submit 17 minus 1, 16 judges. The present bench of 8 learned judges consists of all 8 judges are amongst those 16 judges, because all of your lordships were judges at the time of passing of the 26th Amendment. What we are seeking here is that, including these 8 judges, there are 8 other judges who were judges of this Honorable Court at the time of passing of the 16th Amendment. So, 8 Honorable judges are here, and we are seeking from this Honorable Court for a decision to include the other 8 judges who were judges at that time when the 26th Amendment was passed, and who continue to be on this Honorable Court at present, meaning thereby they are all available judges. So for all intents and purposes, these 16 judges full court is available as of today, and we are seeking that let this bench be extended and it turn into a full court of 16 judges. Now, sir, which submissions which I am going to make is all in the context of full court hearing, not in the context of merits, for which we will make submission as soon as that comes. Now, what the 26th Amendment, sir, what the 26th Amendment purports to do, it amends the process of appointment of judges to the superior courts.
एक question meanwhile. Do you agree now this 26th constitutional amendment is part of the constitution?
I don't think so.
No,
That's what I'm going to argue.
Part of the constitution or not?
It is not. As per my arguments come, this amendment is against the very basic feature of it.
मेरिट पे तो बाद में बात करेंगे, अच्छा या बुरे पे बाद में बात करेंगे, लीगल और इलीगल पे, कॉन्स्टिट्यूशन अनकॉन्स्टिट्यूशन पे तो बाद में बात करेंगे। as for today, this is a part of Constitution or not?
My humble submission, after your Lordship amendment,
Mike,
let me complete.
Mike's the one.
Sorry. After your Lordships examine, I'm seeking the larger bench consisting of all 16 judges. If this Honorable Court comes to the conclusion that it was against the basic features of the Constitution, therefore this would cease to exist from the date it purports to have come into force. This is my submission.
देखिए, दो यहाँ कोई क्वेश्चन जब तक क्लियर नहीं होगा तो फिर वो एक पेज पे नहीं शायद आ सकेंगे. देखिए ना, वी आर बाउंड बाय द कॉन्स्टिट्यूशन.
Valid Constitution.
इन आवर व्यू, वो चले आप उसको राइडर आप लगा लें. As per our view, you are also bound by the constitution, unless it is declared as such as you pray. उस वक्त तक हम अगर एक बेसिक पॉइंट पे एग्री नहीं करेंगे. अब डेफिनेटली नेक्स्ट क्वेश्चन यही था, ये जो आपने अभी फरमाया है, व्हाट इज द कॉन्स्टिट्यूशनल प्रोविजन. अब अगर आप ये कहें कि 26th अमेंडमेंट को आप नहीं मानते, वी आर बाउंड बाय दैट, हमने उसके मुताबिक चलना है, हम तो नहीं कर सकते अनलेस इट इज डिक्लेयर्ड. अदरवाइज जब डिक्लेरेशन हो जाएगा तो फिर
जी सही है.
इस वक्त आप भी जो आर्गू करेंगे डीमिंग इट की पार्ट ऑफ द कॉन्स्टिट्यूशन, फिर ही हो सकेगा. वरना ज़ाहिर है आप कहेंगे कि हम तो मानते नहीं, बल्कि ये क्या डिक्लेरेशन और क्या फिर वो तो
ये बेंच भी उसी
मेरी गुजारिश यही है,
ये मौजूदा बेंच भी उसी 26 कॉन्स्टिट्यूशन अमेंडमेंट के तहत बनी है और आप इस बेंच में आए हैं,
उसी पर मैं आऊंगा ना.
उसके मतलब ये कि
और हामिद साहब, अगर ये नहीं है, यू से दैट इट्स नॉट पार्ट ऑफ द कॉन्स्टिट्यूशन, ठीक नहीं है, तो व्हाई देन यू हैव चैलेंज दैट? आप समझते हैं तो इसलिए चैलेंज किया.
Not part of the Constitution if my submissions are accepted by this.
कोई तो वो unless
court not cleared
It is the part of it, whether right or wrong,
I'm subject.
but that has not been suspended by this court.
जी जी.
तो
देखिए,
फिलहाल तो है.
आपने जब 26वीं तरमीम की वैलिडिटी के बारे में सुनना है, आपने 1 मिनट के लिए एक दफा फिर 21वीं 21st of October पे जाना है, क्योंकि at that time it was passed. And in all such cases, whenever a part of the constitution or amendment is struck down, it is struck down from the very date when it was introduced to begin with. So that is what it is. For the time being, all I have to show before this honorable court that what is the effect of this amendment, and being effect of this amendment, does it affect the very basic features of the constitution? Not
हामिद साहब, वो मैरिज पे है. हामिद साहब, इस वक्त जो है ना वो हम प्रीमेच्योर स्टेज पे जा रहे हैं.
नहीं,
अभी आप सिर्फ जो है ना कॉन्स्टिट्यूशन ऑफ बेंच के ऊपर, इफ यू विल कन्फाइन योर आर्ग्यूमेंट्स फॉर द कॉन्स्टिट्यूटिंग द फुल कोर्ट, दैट वुड बी बेटर, बिकॉज आपकी स्टील में हम सुन रहे हैं, वी आर नॉट हियरिंग इन मेन केस टुडे ना. So I hope you
basically
can to that.
The primary arguments which will be there for your lordships on merit, which I am not going at, but just for the sake of submission that a full court may be constituted, I will only refer to those, not yet saying that how they are against the basic features. I will not argue that now. I'll argue that later. But I'm just showing that one of the basic features of the Constitution is the independence of judiciary. And what I am trying to submit here, by amending Article 175A, the independence of the judiciary has been adversely affected. So that's only to this extent I'm making. The other is that the separation of powers have been affected because under Article 191A, which is the product of the 26th Amendment, now appointment of judges or formation of benches, which was always the function of internal function of the Supreme Court, the Chief Justice, or later when that law was brought in, which made the committee of Chief Justice and two senior most judges,